Greetings and welcome to today's episode of Courts This Week on Live Law. I am Tanya Pandey, here to walk you through the most recent legal developments taking place in Indian courts. Do subscribe to our channel to continue watching this series. As usual, let's begin today's episode with the Supreme Court judgments. 13 prisoners who had been lodged in Agra jail for periods ranging from 14 to 22 years, despite establishing that they were juveniles at the time of offence, have been granted interim bail by the Supreme Court. The plea submits that despite rulings of the Juvenile Justice Board under the Juvenile Justice Act, wherein it was held that the petitioners were juveniles as they were all below the age limit of 18 years, the state of Uttar Pradesh had failed to take any steps for their release, thus keeping them illegally detained. Stating that Article 21 of the Constitution of India guarantees right to life and personal liberty, the prayer was made for the immediate release of petitioners in light of the Juvenile Justice Board order. The Supreme Court has issued directions to the Union Government to ensure that vaccination takes place for mentally ill patients who have been institutionalized in hospitals and mental asylums. The direction was given by a bench of Justice D.Y. Chandrachud and Justice M.R. Shah, who were hearing a matter pertaining to directions being sought to rehabilitate thousands of mentally ill patients who had been languishing in hospitals and asylums. The court further issued directions to the state of Maharashtra to discontinue the practice of shifting mentally ill patients from institutions to beggar homes or old age homes on the ground that it was counterproductive and contrary to Section 104 of the Mental Health Care Act. The bench also issued directions to states and union territories to extend their cooperation with the directions of the court and to ensure that representation was made at the meeting convened by the Union and Department of Social Justice. Summoning of officers frequently is not appreciable at all and is liable to be condemned in the strongest words. The bench of Justices Sanjay Kishan Kaul and Hemant Gupta has observed, while disapproving the practice in certain high courts, to call officers at the drop of a hat and to exert direct and indirect pressure. While hearing an appeal against an Allahabad High Court judgment, the Apex Court noted that the High Court had summoned the Secretary, Medical Health, to the court. The line of separation of powers between judiciary and executive is sought to be crossed by summoning the officers and in a way pressurizing them to pass an order as per the whims and fancies of the court, the bench said. The court also observed that summoning of the officer is against public interest as many important tasks entrusted to him get delayed, creating extra burden on the officer or delaying the decisions awaiting his opinion. IAS officer Vinod Kumar had approached the Apex Court by filing a writ petition under Article 32 of the Constitution, seeking quashing of about 28 cases against him. The bench of Justices U.U. Lalit, Indira Banerjee and Ajay Rastogi said that the petitioner could file appropriate applications under the Code of Criminal Procedure, seeking quashing of the individual criminal cases or complaints. The petitioner's submission was that he had already filed applications under Section 482 of CRPC before the High Court. Dismissing the writ petition, the Supreme Court reiterated that dismissal of an earlier Section 482 CRPC petition does not bar filing of subsequent petition under Section 482 in case the facts so justify. For convicting an accused, recovery of the weapon used in commission of the offence is not a sine qua non, the Supreme Court observed while upholding a conviction of a murder accused. The bench of Justices D.Y. Chandrachud and M.R. Shah observed that when there are minor contradictions which do not go to the root of the matter or contradictions which are not material contradictions, the evidence of such witnesses cannot be brushed aside or disbelieved. The court also added that the entire evidence should be considered as a whole with the other evidence on record. Mere one sentence here or there to the question asked by the defense in the cross-examination cannot be considered standalone, it said. The Supreme Court has held that the Constitution Bench judgment in New India Assurance Company Limited versus Healy Multipurpose Cold Storage Private Limited, reported in 2020 Volume 5 SCC page 757, which held that the delay beyond a period of 45 days in filing the written statement cannot be condoned by the National Consumer Disputes Redressal Commission operates only prospectively. In this case, the application for condonation of delay was filed prior to the judgment of the Constitution Bench with a delay of 7 days beyond the period of 45 days. NCDRC rejected the application for condonation of delay in filing the written statement, citing the Constitution Bench judgment. Against this dismissal, the party had filed the appeal before the Apex Court. Setting aside the NCDRC order, the bench observed that since the application for condonation of delay was filed prior to the judgment of the Constitution Bench, the applications for condonation of delay ought to have been considered on merits and should not have been dismissed on the basis of the Constitution Bench judgment. The Supreme Court on 2nd July refused the prayers made by Punjab National Bank and Union Bank of India to stay the RTI notices issued to them by the Reserve Bank of India to disclose information related to defaulters list, inspection reports, etc. A division bench of Justices S. Abdul Nazir and Krishna Murari, however, issued notice on the writ petitions filed by the banks and posted them along with similar petitions earlier filed by the State Bank of India and private banks HDFC Bank, Axis Bank, ICICI and Yes Bank. The bench had refused interim reliefs to those banks as well. The Supreme Court on 8th July refused to quash the summons issued to Facebook India Managing Director Ajit Mohan by the Peace and Harmony Committee of the Delhi Assembly Committee, seeking his appearance in an inquiry to probe the role of fake social media posts in creating communal riots in Northeast Delhi in February 2020. However, the bench of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy held that the Delhi Assembly's inquiry cannot encroach into prohibited domains of law and order and criminal prosecution, as they are subjects under the domain of the Union Government. The court rejected the argument that the Delhi Assembly has no legislative competence to inquire into the matter of Delhi riots. The court also observed that Facebook cannot take a simplistic approach that it is merely a platform hosting third-party content with no role in generating, controlling or modulating information, and that Facebook's role is not so innocuous and is more active while dealing with third-party information. The Supreme Court expressed shock at the practice of police registering FIRs under Section 66A of the Information Technology Act, which was struck down by the top court in the 2015 judgment in the Shreya Singhal case. A bench headed by Justice Arif Nariman was hearing an application filed by People's Union for Civil Liberties (PUCL), seeking various directions and guidelines against the FIRs under the struck down provision of Section 66A. Senior advocate Sanjay Parikh, appearing for the petitioner, said that even after the provision was struck down, over thousands of cases have been filed across the country. Let us now go over judgments from the High Courts. The Kerala High Court on 9th July issued notice on News Broadcasters Association's plea challenging the new IT rules on the ground that they give government authorities excessive powers to unreasonably and impermissibly restrict the freedom of speech and expression of the media. In light of the interim order passed by the Kerala High Court in Live Law Media Private Limited versus Union of India, Justice P.B. Suresh Kumar has also restrained the central government from taking any coercive action against NBA under the new IT rules. The petitioners had contended that the Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021 are ultra vires the Information Technology Act 2000, apart from being violative of Articles 14 and 19(1)(g) of the Constitution. The Delhi High Court on 9th July dismissed the plea filed by Delhi riots accused Gulfisha Fatima seeking her release, after observing that the court cannot decide the validity of a remand order in a habeas corpus petition. A division bench of Justice Vipin Sanghi and Justice Jasmeet Singh dismissed the plea and said that the petition was completely misplaced and not maintainable. Gulfisha had sought her release in an Unlawful Activities Prevention Act case relating to the alleged larger conspiracy that led to the Northeast Delhi riots in February 2020. The Jammu and Kashmir High Court has held that when a person is charged under the provisions of both the Unlawful Activities Prevention Act (UAPA) and the Narcotic Drugs and Psychotropic Substances Act (NDPS), Further custody beyond the period of 180 days prescribed under the UAPA may be granted under Section 36A of the NDPS Act. Section 167 CRPC provides that when a person is in custody, time for investigation cannot ordinarily exceed beyond a period of 15 days, but it is extendable to a maximum period of 90 days upon the magistrate being satisfied. This general rule also gets modified application under the special enactments of UAPA and NDPS Act, allowing the investigating agency to take remand beyond 90 days. A division bench of the Kerala High Court, while hearing a PIL, directed the state government to seriously look into the implementation of the Dowry Prohibition Act and the rules framed thereunder. Chief Justice S. Manikumar and Justice Shaji P. Chali also directed the state to inform the court as to the steps taken since 2004 in the implementation of the rules. Additionally, the court sought an explanation for the non-appointment of a regional dowry prohibition officer in the state. The directions were issued considering the fact that despite the increasing number of dowry deaths being reported in the state, no action has been taken to implement the concerned act and rules till date. The primary contention in the petition was that the dowry prohibition, maintenance of list of presents to the bride and bridegroom rules have not yet been implemented in its letter and spirit in the state. The Allahabad High Court has rejected the plea filed by Secretary of the Garib Nawaz Masjid Committee, Muhammad Anis, and a local resident of Barabanki, Muhammad Naeem, seeking quashing of the first information report registered against them by the Uttar Pradesh Police. The FIR in question was registered against them and a news portal, The Wire, and its two journalists who are associated with the portal for their report on the alleged Garib Nawaz Mosque illegal demolition issue in Uttar Pradesh. The bench of Justice Ramesh Sinha and Justice Narendra Kumar Johri said that it would remain open for the petitioners to file a pre-arrest bail in the matter and that the court cannot quash the criminal proceedings. Noting that the uncanny timing of the FIRs cannot be lightly brushed aside, the Calcutta High Court on 9th July restrained the West Bengal police from arresting a BJP leader who was earlier with TMC in connection with 13 FIRs registered against him within a span of 30 days just after announcement of West Bengal State Assembly results. In the writ petition, TMC turned court Dhyanesh Narayan Guha averred that between 14th May 2021 and 18th June, 13 FIRs had been registered against the petitioner based on complaints received from 13 different persons. In such a situation, the court added, the court's power under Article 226 of the Constitution of India must and should be exercised to come to the aid of a citizen whose personal liberty is at threat. These were last week's top updates. Subscribe to Live Law to continue being up to date on the latest judgments which I bring to you every week. Thank you for being with us. I am Tanya Pandey and I wish you a peaceful and beautiful week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.